The Uniform Code of Military Justice in Article 36 sets minimal ground rules for military justice writ large. And it says that the President can't act in ways that are contrary to or inconsistent with this chapter. As Judge Robertson found, already we know that has happened here. Mr. Hamdan has been kicked out of his criminal trial right at the get-go. And the government's position is that they don't have to abide by the UCMJ, which is a further reason, of course, why we believe that abstention isn't appropriate, because it defies the rules set out by Congress. We're asking this Court to apply the minimal rules of the UCMJ to the military commissions that operate at Guantanamo Bay, because Article 2 of the UCMJ has been extended, and its protections now extend to Guantanamo Bay and protect those who are detained there. And one of its protections is the right to be present, and that has been fundamentally violated by already. If I could,
you acknowledge the existence of things called commissions, or don't you?
We do.
I mean,
absolutely.
What is the use of them if they have to follow all of the procedures required by the UCMJ? I mean, I thought that the whole object was to have a different procedure.
Justice Scalia, that's what the government would like you to believe. I don't think that's true. The historical relationship has been that military commissions and courts-martial follow the same procedures. That's what General Crowder said when he testified in 1916, and what this Court has quoted from his testimony. It's what every military treatise says. Now, to be clear, our position is not that military commissions must follow all the rules for courts-martial. Not at all. They must follow the minimal baseline rules set in the Uniform Code of Military Justice by Congress. They can depart from the panoply of rules, the 867 pages of rules in the Manual for Courts-Martial, so long as they don't depart from the UCMJ itself. Congress has answered this question, Justice Scalia, in Article 36 by saying the President does have a wide ability to depart from the rules, but he can't depart from the fundamentals of the UCMJ. And indeed, that's what
fundamentals other than personal presence are you concerned with in this case, or is that it?
Well, we do believe that the entire panoply of UCMJ protections.
I understand the nature of the appointing authority and so forth, but so far as the rights of the defendant at the proceeding, just right to be present, is there a requirement of prompt convening of the proceeding?
Absolutely. There's an Article 10 right for speedy charges. There is also an Article 67 right for independent Court of Appeals for the Armed Forces review, which is something that is not guaranteed by this Commission. And indeed was a predicate for this Court's abstention holding in Councilman. So we do believe that that these fundamental rights apply. And of course, this is just all Justice Kennedy default rules. If the Congress wants to pass a law to exempt military commissions from Article 36, that they are free to do so, and that'll then be a separate.
You have to have approximately the same procedures. What's the point of having a military commission? I think that was implicit in Justice Scalia's question. So if you go back, Revolution, Seminoles, MODOK, Mexican War, World War II, why have them?
Well, we had them before because we couldn't find military court-martial jurisdiction. They were situations of absolute necessity. The reason was that the Articles of War, for one reason or another, didn't cover particular individuals, and therefore we needed to craft a separate procedure. But whenever we did so, Justice Breyer, we always said that court-martial rules apply. In 1847, which is really the first instance of a military commission, because General Washington operated under statutory charges to try spying. But in 1847, we applied court-martial rules by General Order No. 1. In the Civil War, we applied General Order No. 1 again, and it said that we needed to apply court-martial rules because otherwise abuses would arise. And essentially, the worry is one of forum shopping, that you give the president the ability to pick a forum and define the rules. And that fundamentally open-ended authority is what I believe this Court rejected in Hamdan and when it rejected the blank check.
Mr. Katyal, you've addressed the Detainee Treatment Act in its capacity as arguably removing jurisdiction. Might not the Act also function as a retroactive approval of what the President has done?
Certainly there's nothing in the text of the Act itself, and even I know this isn't relevant for you, but for other individuals on the Court, there's nothing in the legislative history or even the brief filed by Senators Graham and Kyle which suggests in any way that this was ratification. But suppose it were, Justice Scalia. Suppose it did ratify some sort of military commission. I don't believe that it authorized this military commission with this charge, conspiracy, in this conflict, a stateless, territorialist conflict, with these procedures that violate the UCMJ. So it may be that they authorized something. But even that, I think, may be a bit hard because, after all, what they did was authorize, as Justice Alito said, certain challenges to military commissions.
Do you think as a minimum that they authorize a military commission?
I think it's perfectly it is a possible reading to say the DTA authorized some sort of military commission. The text doesn't say so. It is, of course, addressed to the jurisdiction of this Court and not in any way to the underlying merits. I do think that there is a conceivable argument. However, the reason why I think this Court, if it did decide to reach that ultimate question, should reach it against the government is that kind of backdoor kind of approval by inference has never been sufficient when it comes to authorizing military jurisdiction and the most awesome powers of the government to dispense life imprisonment and death. That is, I think a clearer statement would be required in this unique setting, because we aren't talking about, after all, minor things. We're talking about the most grave powers of our government, the power to dispense life imprisonment and death. And I certainly don't think Congress, on the basis of a few hours of debate, intended to ratify this entire apparatus. If I could turn to question 2 and the Geneva Conventions, I'd like to start with Common Article 3 and its minimal baseline requirements that a regularly constituted court be set up, and one that affords the rights indispensable to civilized peoples. As Judge Williams found below, that article does apply to Mr. Hamdan and protects him. It's the most minimal, rudimentary requirements that the United States Senate adhered to when it ratified the convention in 1955. And those requirements
depends on what you mean by regularly constituted. In your brief, I gather what you meant is a court that was pre-existing. It doesn't necessarily mean that. It could mean one that was set up for the occasion, but was set up for the occasion by proper procedures. Wouldn't that be a regularly constituted court?
Well, I think the way that it has been interpreted, regularly constituted court, is not an ad hoc court with ad hoc rules. So that is to say, Justice Scalia, if they resuscitated...
Well, I mean, not ad hoc in that sense. I'm creating one court for this defendant, another court for the other defendant, but setting up for the occasion and for trying numerous defendants a new court. I don't think that just because it's a new court, you can say that it's not a regularly constituted court.
So long as it is A, independent of the executive, which is what it's been interpreted to be, and B, affords the rights known to civilized peoples. And here we think this military commission strays from both of those.